Hello, everyone. Welcome to another episode of the Unisoft Question, where we interview litigators and other lawyers. And I am Polat Yunusov, the host of the show. Today, we have a wonderful guest from New York, Jason Gottlieb of Morrison Cohen LLP, partner, chair, white collar and regulatory enforcement, and chair, digital assets at Morrison Cohen LLP. Hello, Jason.
Hey, Polat, it's great to talk to you again.
It's really great to talk to you. As I said before we started recording, I think you are the best dressed guest that has appeared on the show so far. I really love your t-shirt. And I also love the background, but then I learned that it's the actual background. The shelves exist in the next room, but it's actually an image, right? So I was really shocked.
It is an image. It's a fake background, but the bookshelves are real. They're actually in my living room. So these are my bookshelves and my books. I should say our books. They're mostly my wife's books. She's a professor.
Jason, I believe, and I've been known to be wrong about my past guests, but I believe you are the first American lawyer on this show. I think it's a momentous occasion. It's some kind of watershed. So what I want to talk today about is I wanted to, Canadians do this all the time. I want to compare Canada with America.
Okay, and we're warmer.
Yeah. But before we do that, I want to follow my usual protocol, and I want to talk a little bit about where you came from. Usually I ask people where they were born. My first question is usually, are you from Toronto originally? Obviously you're not originally from Toronto, but I will not be surprised if you are. So where are you originally from?
Not from Toronto. I was born in Colorado Springs, Colorado. Both my parents are originally New Yorkers. My dad was in the U.S. military in the Air Force, so he transferred around a little bit before I was born, and he was stationed at NORAD, the North American Radar Defense System, buried in Cheyenne Mountain, right outside Colorado Springs. So I was born in Colorado Springs, but I moved back to the East Coast at some point. So I went to high school and college on the East Coast in New Jersey. And then I traveled around the world a little bit. Did graduate school at Harvard for a year and a half. Went to Tokyo to work at a computer company for 2.5 years, and then back to New York to Columbia Law School.
Speaking of the NORAD mountain, I know there are some Canadians in that mountain. Have you met them?
I'm not sure how many Canadians are going to be in a highly classified military intelligence.
Oh yeah. It's NORAD is a joint U.S.-Canadian command.
Really? I didn't know that.
So this is the first revelation about what Americans know about Canadians on the show. There are actually high-ranking Canadian officers in that mountain. So the high school, I'm looking at your LinkedIn. People don't usually put high schools on LinkedIn. You did. So what was so special about this high school? Fort Lee High School, 86 to 90. Where was it?
In Fort Lee, New Jersey. It's just the public high school in Fort Lee, New Jersey. And I put it there because I was proud of it and happy to go there. Nothing more.
You were admitted to Rutgers University in 1990, and I know who you met while you were on the debate team at Rutgers. You met Michael Lubetsky, one of the former guests of the show.
I saw the interview that you did with Mike. It was a terrific interview. I had a chance to meet Mike. We overlapped. Rutgers is just sort of right up the street from Princeton, and we worked together a lot. We spent a lot of long hours in car rides together up and down the East Coast, going to various other universities for these debate tournaments on weekends. So I got to know Mike, and then we reconnected when we both lived in Japan at the same time. So we've been friends for hate to admit how many years it's been, but you're naming years already. So it's, going on 30 years now.
Right. And today he is a very senior, respected tax partner at a white shoe firm here in Toronto, and a guest of the show as well. I understand that you had not met any Canadians before you met Mike in New Jersey, because you didn't meet any Canadians in Colorado. Is that correct?
Even though apparently they were there around me all the time, I just didn't know it. Yeah, I don't really remember. I don't remember a large Canadian contingent at my local high school in New Jersey. I'm sure we had a whole group of them at Rutgers, which is Rutgers is the state university in New Jersey. So it's a very, very large school. So I'm sure there were some, but I don't particularly remember much about it.
This sounds like a funny question, but it's a very serious question. Let's use you as a sample of one. And, let's call this a qualitative study, which is another word for inadequate quantitative study.
Lawyers doing science, man.
Yes, lawyers doing science, exactly. Let's call this evidence, because there is no other evidence, so it has to be the best evidence then. Did you think about Canada at any point in your life before you became a lawyer in any shape or form? Was it on your radar at all?
But before I went to a law school, when I was in graduate school, I lived across the hall from a Canadian who invited me to a Canadian Thanksgiving dinner at Harvard. And we had a really great conversation there. I met some prominent former Canadian politicians, including Kim Campbell, and we had a spirited discussion about whether this was back when Quebec was voting whether or not to secede. And I volunteered that I thought that if Quebec voted to secede, then they would cut off the Maritimes. So they should also vote to secede, and they should join the United States, which everyone found absolutely absurdist. And I think I was mostly kidding about it, but who knows? So things like that had been in the news, obviously, in the United States. It was a fairly significant event or issue, even down here, the Quebecois secession question. So every now and then we'd think about it, but for the most part, I think your audience would agree that Americans are wonderfully solipsistic, and we only think about ourselves.
I'm asking you for a good reason. You're not just a random American. You are actually involved in Canadian matters, Canadian legal matters, not personally, but in your professional capacity. So you were involved in the famous and probably the sole crypto litigation proceeding in Canada, the Medvedovich case. And I think it's really the most interesting Canadian cryptocurrency case before the courts right now. So you worked with Canadian counsel professionally, and you just told me about your other encounters with Canadians. What is the reputation of Canada among American lawyers? And you know what? Before you answer this question, I have to qualify this. I think it's wrong to speak of American lawyers just as it's wrong to speak of Canadian lawyers, because the legal profession is very fragmented in the US, just like it is in Canada, by state and by province. So let's limit this to New York lawyers. So you're a New York lawyer, you're a quintessential New York lawyer, you're a New Yorker, you work in Manhattan, you're like one of those New York lawyers from the movies. You talk to other New York lawyers. What is the reputation of Canada? What do New York lawyers think of Canada when you mention Canada in your conversations?
It's funny you should say a quintessential New York lawyer and ask what we think, because for the quintessential New York lawyer, if you get five of us together and ask us any question, we'll have about 15 opinions, and we'll voice them all loudly and quickly. Look, like any group of people, it's going to vary widely. But I've been very fortunate in my practice that the Canadian lawyers that I've worked with have been absolutely wonderful to work with. I've, in addition to working with Mike Lubetsky and his partners at Davies Ward, you mentioned the Medvedev. I'm sorry, I still have trouble pronouncing it, but Andayan's case, the cryptocurrency case, and there I've worked with the with the team from Stockwoods, Gerald Chan and Stephen Aylward, and they've just been absolutely phenomenal lawyers to work with. Very smart, understand this space very well. So, from my point of view, I may be spoiled having had access to only the very top Canadian lawyers, litigators, but from that, I can say my opinion of them is extremely high.
Yes. I want to make this a theme of this conversation today, how the Canadian legal landscape compares to the American legal landscape. But I want to focus on litigation because I'm a litigator. And I want to focus on New York and Ontario because I think that, as I said before, there is probably as much difference between North Dakota and New York as between Ontario and New York. And by the way, one of the
differences between the regions. New York litigators have a certain style and a rhythm and a cadence and a way of practicing. There's a way that the courts work, and in other parts of the country, sometimes it works the same way, and sometimes it doesn't. I was in one southern state that I won't identify, where I had a local counsel, who wore into the courtroom the big cowboy hat and the bolo tie and the cowboy boots and a little stubby cigar that he kept in his mouth the entire court appearance. And he knew everyone in the courthouse and everyone knew him. And after the hearing, the judge stepped off the bench and was chatting with my local counsel and the other side's local counsel about where they were going to go dove hunting that weekend. And I have to say that us out of town New York lawyers were kind of standing back thinking this is not the way this would go in a New York courtroom. But that's okay. I mean, every one of the cool things about America is that we have so many different customs and practices across the states. People are going to be regional, and even within the regions, there are lawyers who kind of fit into the local stereotypes. You mentioned the quintessential New York lawyers. We've got our own stereotypes, and then there are lawyers who don't fit that or who transcend the stereotypes. It's a very varied practice.
What is one thing about the New York lawyer or about the New York courtroom or about New York litigators that will strike a lawyer new to New York State or to New York City as something common to that culture or cadence, as you said?
There are even differences between our federal system and our state system. For example, in the state system, if you're up for an argument, the judge has 30 other cases waiting. You're going to get 5-10 minutes maybe, and you're going to speak very quickly, because if you take a breath or pause, sometimes you'll get interrupted by your opposing counsel, by the judge, sometimes by people in the peanut gallery. It can be a little bit more of a free for all, and you're sort of expected to just jump right in and get to the point. The federal courts, you may have more time allocated for you and only you. It could be a little bit more formal, a little bit more of a presentation, and the judges can have more control over their calendar. So I've had an argument that was scheduled for an hour end up going 3 or 4 hours because the judge just really took an interest in the material and wanted to dig in and answer all the questions. So you'll have even different experiences, in courtrooms that may be across the street from each other just because of the style of that courtroom and what's on their docket. So I think that most people would expect the federal system where lawyers stand up and can orate at length about their view of the case law, and most of New York justice gets done in the state courts where it's much more rapid fire, free for all.
So I'm really curious about the distinction between the state and the federal court system in the US. I understand that they have concurrent or overlapping jurisdictions. So the same case, so there is an option, there is a choice to where to bring the case. And in Canada, for example, very generally speaking, they don't have overlapping jurisdiction. Of course, superior courts of provinces have inherent jurisdictions. So in theory, they can take any case and they have the power, the inherent power to hear any case. But in practice, the federal courts in Canada are creatures of statute, and they were created specifically by legislation to address specific scope and subject matter. So for example, telecommunications or patents or interprovincial affairs and things like that. So I want everyone to go and watch the interview that I did with Justice Stratus of the Federal Court of Appeal of Canada, where we talk about that, and he is one of the brilliant judges of Canada. But I think that as far as I understand, in the US, that's not the case. Can you shed some light on that, please?
Sure. We also have a dual system, a federal court system and a state court system. Our federal court system is a system of limited jurisdiction. The federal courts can take on cases where there is either a federal question, so as you were just responding to, if there's a question involving a federal statute or issues of federal law, then federal court jurisdiction is appropriate. The federal courts can also take on cases that are known as diversity cases. That is, you have citizens from different states involved, and the matter in question has to be over $75,000. So it has to be a matter of more than just trivial import. In that case, a federal court can hear the matter. And the idea there is just because they don't want, someone from New York to sue someone from Texas in a local New York court where it might be unfair to the Texan, and vice versa. So the idea is if you have people on different sides of the V from different states in a matter of some import, you can take that to a federal court where, in theory, you'll have a more neutral hearing. You won't have judges who may be local elected judges. So that's the system. And in theory, it sounds pretty simple, but could actually get to some really complicated problems. So, for example, in the federal system for diversity, you have to have complete diversity. All the people on one side of the V have to be from different states as all the people from the other side of the V. But an LLC or a partnership for diversity purposes takes on the citizenship of all of the members of the LLC or all the members of the partnership. So if one person is suing an LLC, that person has to plead the citizenship of all of the members of the LLC. And if there are members of the LLC that are themselves LLCs, all of the citizenships of all of the members of that sub LLC, in order to make sure that there is complete diversity. If there's not complete diversity, at any point in the case can be dismissed out of federal court. So I've been involved in cases where one person in a partnership sues the partnership, and nobody realized that actually knocks it out of federal court until quite later in the case. And once it's realized, everyone may be very annoyed that they've wasted all that time in the federal court, and now they have to start over again in state court. But that's the rule. That's what happens. So it's not exactly the most efficient system sometimes, but that's the system we have.
Fine. So I understand that essentially there is a burden on parties to justify their presence in the federal court system, and they may be called upon to discharge this burden at any point in the proceedings. So essentially, the federal courts don't want you unless they're really sure that you belong.
Yes, they cannot, the federal court cannot hear the case unless they have jurisdiction. And if they don't have either subject matter jurisdiction or diversity jurisdiction, then they have to dismiss the case. And at that point, it has to be brought in a state court. The state courts, as you said, something like the provincial courts, can take any case. So, if there's some doubt, you can sue in state court, and the state court should hear it. Although there's a process to remove a state court case if it belongs in federal court. So if I brought a case in state court and my opponent thinks actually there is subject matter jurisdiction or diversity jurisdiction, they can remove it to the federal court. And then I have to go to the federal court. And if I agree, we just stay in federal court. But if I disagree, if I think that the removal was improper, I can make a motion to remand it back to the state court. And an interesting point here is if I win that motion to remand and find that the case was improperly removed, then I can recover the attorney's fees incurred for the remand, for the removal and remand, which is one of the few cases in US litigation where you actually can get attorney's fees from the other side.
Of course, unlike Canada, where you always get the attorney's fees, or we call them costs. So whenever you lose, yep, whenever you win, you get part of your cost. So a couple of questions in that respect, in respect to the distinction between the state and the federal courts. You said that you can remove a case from the state court to the federal court system if the federal court system has jurisdiction over that case. But I understand there is no pressure to remove a case from the state court, in the sense that the state court simply has no jurisdiction, just like the federal court has no jurisdiction. State courts always have jurisdiction. So is the basis for removing an inconvenient forum then, rather than absence of jurisdiction?
So inconvenient forum is a separate basis. There's sort of two questions that you're asking here. So one is, let's say I sued on behalf of a New Yorker. A New Yorker sues a Texan in the New York State Court. The Texan could decide I'd rather be in federal court and attempt to remove the case to federal court. But if for whatever reason the Texan said, no, I like this judge, I like this court, I'll stay in state court, there's no mandatory removal of that case. So that case can proceed in state court, and the judge there will hear it and probably isn't going to ask, why isn't this in federal court? That it may not be the case if there is a federal question. So if the parties, if I sue someone for a federal securities fraud matter in a state court, and that person decides not to remove it to federal court, the judge may say, why is this in front of me? Doesn't this seem like a question of federal law? But the judge still has jurisdiction to hear that case. So that's the answer to your first question. On the inconvenient forum, there's a separate doctrine, forum inconvenience, or forum non, as we call it, where you can say this isn't the right forum for this matter. And that's separate from the jurisdictional point. That's saying, if I brought a case on behalf of a Texan against a Californian, and I brought it in New York just because I happen to be in New York, then the California citizen may say, this is silly. This doesn't belong in a New York courtroom. This has no connection to New York. This belongs in either Texas or California, but not in New York. So that would be an example of a forum non-argument.
In practice, because the United States is an interconnected country, it's not a union of sovereign nations. It's a country comprised of states with some sovereignty, with some jurisdiction, but it's still a united country. And
well, that's been a 240-year-long argument, but yes, essentially that's right.
I thought the Civil War resolved that argument, didn't it?
So did we all.
Okay, we'll see what happens. So the question is still open. But my point is, because there's so much interstate trade, because all of the brands are American, not, state brands, all of the brands that are on everybody's mind. Of course, there are state brands, right? But the biggest things are American, not Californian or New York. For practical purposes, in practice, is the federal court system the biggest court system in the United States? Does it dwarf state courts? Are most cases in the federal system?
I think the answer to that is no. Most cases are in the state system, just because the federal courts can only take certain kinds of cases, whereas the state courts can take more. And I think more cases, just in terms of averages, don't forget things like small claims court or other kinds of places. As soon as we're saying a federal court is for diversity for matters over $75,000, many of the sort of bigger ticket item that people at big law firms will work on, a $75,000 threshold can seem trivial. But for most people and most disputes, $75,000 is a lot of money. So you have a lot of disputes that play out in small claims courts or in courts that are slightly below, sort of premier commercial divisions in the state courts. And a lot of litigation happens there. Things like landlord-tenant litigation, family law, et cetera, that all takes place in the state courts. In terms of the business litigation, I think it's sort of probably equal between federal and state, and it's really largely a question of coincidence, right? Where are the parties from? But those issues of federal importance all get played out in the federal courts.
So speaking of business litigation and the parity that you mentioned between state and federal courts in business litigation, would you say that most state courts are in the Court of Chancery in Delaware? I'm sorry, most state business litigation.
I think there's an overwhelming, or rather a disproportionate amount of business litigation that happens in the Court of Chancery in Delaware, partially just because so many corporations are incorporated in Delaware for historical purposes. Delaware has tried very hard for a long time to have a very corporate-friendly, business-friendly legal system, corporate law, statutes. And the Court of Chancery is generally comprised of, some of the best corporate law minds in Delaware who understand it. So it's probably one of the premier business litigation courts in the United States. But apologies to my friends in Delaware, I'll have a little New York pride. New York is still the center of commerce in America. So it's hard to say which is more relevant between the Delaware courts and the New York courts. Obviously you have a lot of very high profile things taking place in the Delaware courts. That just the most current example, Twitter just sued Elon Musk in the Delaware court over that merger agreement, and we'll see what will happen there. But I think you have premier commercial litigation filed in the federal and state courts of New York all the time, every day. So I'll have a little New York pride for that. But also, we can't forget some others, right? The Southern District, the Central District of California, which is the federal court covering Los Angeles, as well as the Los Angeles state courts, have a lot of big business litigation going on. The Northern District of California, which covers the San Francisco area, is, for pretty obvious reasons, it covers Silicon Valley. So it's a hub for a lot of high tech litigation issues. You get a lot of high profile cases coming out of there as well.
I want to share a New York story, if I may, because you mentioned, you mentioned the New York pride. And it's probably one of my favorite stories. It's very short and simple. It just shows you how much of a fan I am of that person. So I was in New York in 2017 on business, and I went to Brooklyn Diner. And for those who don't know, Brooklyn Diner is not in Brooklyn. It's on West 43rd Street in Manhattan, in Midtown, I think. And I went there with my wife, and we were sitting down. So when I entered the diner, the host had this mysterious look on his face, and he had this Mona Lisa smile as he was taking us to our table to sit down. Okay, whatever, maybe New Yorkers are like that, thought I. And then he put us down. He sat us down at our table. We sit down, and then my wife looks at me and she says, "Jerry Seinfeld is next to you." And I thought she was just joking, right? I thought it was a joke. And then I turned my head, and I could stretch my arm, and I could pat him on his back. So I spent an hour having lunch with Jerry Seinfeld, sitting next to me pretty much, and talking to some Hollywood guy. I don't remember. I recognized him, but I can't remember his name. So I had my personal Seinfeld episode basically while having lunch, and I can't forget that story. It's really, to me, this is New York. When I think about New York, I remember this story. So I'm a huge Seinfeld fan. And I can't forget, I think it was one of the best moments in my life. And that's what I will associate New York with forever, probably.
We have a lot of every New Yorker's got their great stories. I mean, there are so many sort of famous people who live here and work here, and of course, you know, even famous people, they eat and they do kind of normal things. I sat next to one of the big Yankees stars at a circus for kids. So we all had our kids crawling all over each other, and we were, you know, just kind of two dads out with the families. You know, we've had other encounters with athletes or kind of you know, movie stars, that sort of thing. And you just got to, you know, if you're a New Yorker, you just play cool. Yeah, how are you doing? I was eating with a client in one restaurant where I saw you know, the new James Bond. He was very, very suave, very good looking. And when I looked up at him and he looked down at me, and we sort of met eyes for a minute, and he just, as he passed our table, looked at me and said, "It's nice to see you again." And I said, you know, gave him a little nod. And I've never seen this guy other than on a movie screen. I have no idea who he is. But you know, my lunch companion was extremely impressed. "You know James Bond?" Like, no, I do not. I do not.
That could be a new way for you to introduce yourself. "Hello, I'm Jason. I know James Bond." You know, when you mentioned seeing the baseball star, I remember the Seinfeld episode where Kramer ran into Joe DiMaggio at the donut shop. Sorry, I just think in Seinfeld episodes. I'm sorry. I'm rewatching the whole show now on Netflix, so it's on my mind. Anyway, so I wanted to go back to the federal and state court system, and we talked about the balance or the proportionate shares of each court system in the American litigation landscape. Is it fair to say that the federal rules of procedure set the standard for other rules of procedure in the US, or does every jurisdiction try to be independent and does its own thing?
There's a mix of that. I think for the most part, the rules of procedure are reasonably standardized, at least in principle, right? In New York, we call it a motion to dismiss. In California, maybe it's a demurrer. In Texas, they try not to have those at all in the state courts. But there exists the same principles across most of the states. They're just little variations. So obviously the federal rules of civil procedure, the federal rules of evidence, federal rules of criminal procedure are all standardized in every federal court in the country. But even after that, you'll have the federal rules, but there's a lot in the gaps of the federal rules. So each district can have its own district's local rules. The Southern District and Eastern District of New York, covering basically Manhattan and Brooklyn and Long Island, have a set of local rules, and each judge has their own individual practices that and they put it on the website. So, knowing the federal rules in a New York court are not enough. When you go out to California, there are different ways of doing things. Even just the timing on briefs and arguments have different ways. In the Southern District of New York, and this is all in the federal system where it's supposed to be standardized. I would file my motion, generally speaking, and then there are X days for opposition, X days for reply, and then the judge can set oral argument whenever the judge wants to, and the parties will wait for a hearing if there's going to be one until the judge is ready. Whereas, in a California federal court, you set a hearing date, and then you work backwards from there to set when the briefs are going to be due. Now, practically speaking, in both cases, parties will just agree on a schedule. But these kinds of differences show that the rules, even when they are harmonized, aren't really that harmonized. You multiply those differences when you go into the states. The New York civil procedure rules are a completely different thing. And of course, they have a lot of the same principles, but a lot of the rules are fairly different in terms of how practically things are going to be accomplished. And you have definite differences, regional differences. And those differences can be both explicit in these rules, and sometimes they're implicit. I'm always surprised at how quick the Texas lawyers are to tell me that in Texas state courts, motions to dismiss or demurs are just routinely denied. You're going to go to discovery. Don't bother making it, and we shouldn't even try to get out early. Whereas in the New York courts, it's much more common to make a motion to dismiss at an early stage. And if you can make an argument that the complaint does not allege a claim for whatever reasons, you actually have a reasonably good chance of getting out. So differences, what's the system, the saying, two countries divided by a common language. We are, 51 systems divided by a common set of civil procedure rules.
This is so interesting. I think Ontario is much more like Texas than New York when it comes to motions to dismiss. It's rare for them to succeed here in Ontario. So, and let's make sure I understand you correctly.
That's a great phrase to take out of context. Ontario is much more like Texas. We have to cabin that a little bit.
Yeah. In motions to dismiss area. So I just want to understand, when you refer to motions to dismiss, and by the way, I wanted to ask you specifically about motions to dismiss because I lurk on various lawyers' online forums. And most lawyers there are American lawyers. And when they talk about cases, I often hear about motions to dismiss. So it seems like if there are 3 stages to litigation in Ontario, pleadings, discovery, trial, it seems like in America, there are 4 stages to litigation: pleadings, motion to dismiss, discovery, trial. Commonly,
I'll add a fifth in there. We have a summary judgment procedure as well.
Okay, so this is fascinating. This is what my question is about. So are you talking, when you talk about the motion to dismiss, is this a pleadings motion then? So basically dismiss the case because the pleadings do not disclose a cause of action, right?
That's correct. So
how often can that happen? Why is it common in New York? I don't understand.
Well, it's more common in some areas of law than others because of the standards that are set up. So, for example, and let's just take the federal rules of civil procedure. So Rule 8A governing pleading standards says that most causes of action only need a short, plain statement of the cause of action. So take a negligence claim, right? For physical damage. If I allege, Poulat was walking down the street and was carelessly swinging around a baseball bat and he hit me in the head, and I've been injured and I'm suing him for negligence, that case would be very difficult to dismiss on a motion to dismiss, because the standard for a motion to dismiss for under Rule 8A is that the judge is not going to examine any of the facts. The judge will accept all the facts that were pleaded as being true, as long as they are plausible. So if on the complaint I just said, that's plausible. I mean, it's a little silly that you would have been walking down the street swinging around a baseball bat, but it could happen, right? If I allege that you were walking
it could
down
happen
the street,
in America.
In America, it could happen. It's the least likely thing that could happen in America. If I alleged you were walking down the street, swinging around an alien from Pluto, then maybe that gets dismissed as implausible. But that would be a tough one to dismiss on a motion to dismiss, and frankly, you may not even get a motion to dismiss on that particular issue. However, there are variations. So, for example, negligence that only causes economic loss in the absence of some special relationship isn't even a cause of action. So you may be able to get that dismissed on a motion to dismiss stage. And then when there are certain causes of action that have special pleading standards. So, for example, if you are pleading fraud, a different rule kicks in, and under Rule 9, you have to allege fraud with particularity. All of the elements must be alleged with particularity, including, say, intent. So you have to very particularly allege facts that give rise to a strong inference of intent to commit fraud. And if you do not put those facts in the pleading, then it's ripe for a motion to dismiss based on that absence of fact. So especially in business cases alleging fraud or securities fraud, there are a fairly strict set of hurdles that a plaintiff has to hit in that original pleading just in order to survive this initial motion to dismiss, even taking all of the facts that they allege as true.
So I don't get this. How hard is it to meet technical pleading requirements to avoid a motion to dismiss? It should be pretty straightforward. So is it incompetence that results in a great number of motions to dismiss? Is it ambiguity in the law? What is it? Or maybe is it a lack of tools? It sounds like something that could easily be automated. And my second question, how many kicks at the can do plaintiffs get? Can they get a leave to amend the pleading when the motion is granted? Two questions.
Yeah, I'll take the second one first because it's the easier question. Most plaintiffs will get at least another bite at the apple, if not more, if it's evident that amendment would not be futile. That is, they could amend in a way that would meet the pleading standards. So take this a securities fraud case. I plead that I was supposed to purchase some securities. I gave you the money. You didn't give me the securities. But I don't plead anything about intent. No facts about intent at all. And the judge says, you have to plead facts about intent. Otherwise, I'm going to dismiss it. But I will dismiss this one without prejudice. You can replead because you could plead facts that would get you there. So go right ahead and try again. Judges will freely give at least one retry, sometimes two. After that, your chances diminish pretty successfully, pretty severely. If you can't do it on the first or second try, judge is going to think, yeah, you're not going to be able to do it on the third or fourth, or definitely not the fifth. So you'll see that go down. In terms of the question of how hard is it, it really depends on the circumstances. In something like that, if it was just you and me, right, we're going back to a simplified model. I said, hey, I'd really love to buy those securities from you. Here's all the money. And if you said, thanks a lot, I'm taking your money. And by the way, you're never going to see the securities because I hate you. See you later. That would be an easier case to successfully allege the facts that would infer that you have intent to commit fraud. But it could be a little bit more difficult in a case, and these are the most often cases we see, where a company is going into a merger with another company. And a plaintiff's lawyer will bring a class action saying, we think that you didn't disclose all of the information in the proxy statements or in your public materials that would have enabled us to get a fair price, and therefore we didn't get a fair price and we should have gotten more out of it. Well, okay, but you have to allege that the company or the executives in question intended to omit these materials in order to, change the price in some way. And that can be difficult if you're an outsider to this whole arrangement. And I think there are good reasons to force plaintiffs to have to plead that with particularity, because otherwise you could say that for just every single merger that goes through. I think you omitted something, and if you had only disclosed it, we would have been richer, and therefore you're to blame. You could say that for every corporate transaction ever. So it makes sense to require people to plead a little bit more to show that there could actually be a fraud claim there. The cost of discovery in the United States is a very important factor in making sure that motions to dismiss serve an appropriate gatekeeping function. Because if you sue a big company and they make a motion to dismiss and that motion to dismiss loses, then they're looking at a discovery practice that it's going to be very intrusive, very intensive, and very expensive. 6 figures easily, sometimes 7 figures, and sometimes more for a year-long intrusive practice. So, if you're a big company that gets repeat class action litigation, it could cost you millions and millions and millions of dollars a year in discovery for claims that are bogus, for claims that everyone knows aren't going to go anywhere at the end of the day. But we can make out this facial prima facie case. Maybe something will come out of discovery. Because of these abusive practices, we've actually had a series of laws going back to the 90s, the Clinton era. The PSLRA, the Private Securities Litigation Reform Act, raised the bar a little bit for bringing these actions. And we also had a couple of court decisions, most notably the Iqbal case, IQBAL, which raised the standards for pleading fraud. So we have a situation now where there is a fairly high barrier to plead a case for securities fraud, plead a securities class action. And whether it's too high or not, I'll leave to other practitioners or academics. But it does have to be appropriately high, because if it's too low, then unscrupulous plaintiffs' lawyers can inflict $1 million discovery budget on companies at will, and thus say, I'm going to bring this case against you, but I'll settle for $500,000. And companies will take that deal every day because it's cheaper for them to do so. But these are toll booths on the highways of American capitalism. And we have to find that right balance that allows people to bring good cases where there truly are frauds or wrongs or harms, but not have the barrier be so low that people can inflict these massive bills in order to just extract value from companies where they might not have good cases.
Fascinating. My last question is about, and I wanted to ask you a follow-up question, but I think we're running out of time. This is a really interesting topic to me. But my last question is about delay in litigation. Litigation delay in the courts. We in Ontario are suffering from delay. This is one and probably number one issue here in Ontario. Most cases suffer from delay. Scheduling long motions requires people now to wait for months, maybe a year, to get a hearing date. Is there an issue with delay in New York? Is it a problem? How is it dealt with?
We've always had those problems. I think COVID made that worse because a lot of things got pushed off or scheduled, and the court is still digging through a backlog of, when it was unable to function at all, or when it was unable to function as efficiently because everything was remote and the court system just was not set up for that. So we're still digging through the backlogs. The backlogs are particularly bad in the state system, which is always overcrowded and delayed as it is. I think it's a real problem because things happen more quickly. I practice a lot in the cryptocurrency area, and crypto happens in nanoseconds, right? We've seen massive shifts in market forces. We've seen meteoric rises. We've seen catastrophic falls happen in a matter of days. So when you're talking about needing to take action immediately, and you have a court system that provides no opportunity for taking action in anything less than weeks or months, even a TRO or a preliminary injunction sequence can take a few weeks. These are delays that are really difficult to deal with. And I think the brunt of it falls not on the sort of bigger businesses that have, sure, we've got a business dispute, it's going to take a long time, it'll be inconvenient, but this is the way it goes. And after all, it's just money. It's $1 million one way or the other, which is massive amounts of money to normal people. But for large businesses, they can function pretty much normally during the pendency of a dispute like that. But when you have disputes that are bet the company, as the cliche goes, that doesn't play anymore. And I think it particularly hurts ordinary people who want to have access to justice, but the court system is so backed up that it can't give that to them. So if you are, just to take a landlord-tenant examples, right? If you're a tenant whose landlord hasn't fixed anything since 1957 and your roof is falling in, it can take an embarrassingly long time to get a court to intervene and help fix the problem. To be fair to landlords, if you're a very great landlord whose tenants are just not paying you and refusing to leave the premises, it can take an embarrassingly long time to get the courts to redress that situation as well. So, not putting any blame on anyone in particular here, but for sort of ordinary folks and ordinary business disputes that are of critical importance to your everyday lives, that delay is really difficult. Some judges are taking measures to address it. Some of those measures are better than others. I've had judges put us on lightning fast discovery schedules, and sometimes it's too much, right? A judge says, I want this massive thing to be tried in 6 months, so everyone's going to do all their discovery in 2 months, and all the parties say that's crazy. There's no way we could do that. It's just impossible. But I think that the fixes that are needed are deeper and more structural. I mean, the courts need to be bigger. We need more judges, more court personnel. We just need more resources. And, that's something that I think has to come from legislatures, either federal legislatures for the federal court system, from our Congress, or for states that are dealing with already strained budgets. I'm not so optimistic that's going to happen soon.
Yes, and I don't think anybody is optimistic right now in Ontario, but we always keep our fingers crossed and hope for the best. Jason, I want to thank you on behalf of many lawyers and judges who watch this show, Canadian lawyers and judges. Thank you for this comparative study of the American litigation landscape. It was rare, it was valuable, and it was very helpful. I really appreciate it, Jason. Thank you so much.
That was my pleasure. And, hello and best wishes to all my friends up north.
And they will hear it, I'm sure. Thank you.